Hi guys, welcome to D Jure. Today we are going to do labor law important MCQs part 4. Let's continue with this series. Question number 1. How many days of notice period is mandatory for a workman who has been in continuous service for more than a year while retrenchment? Answer would be option A, 1 month. Question number 2. When the ownership or management of an establishment is transferred, whether by agreement or by law, every workman who has been in continuous service for not less than 1 year is entitled to notice and compensation in accordance with the provisions of which section? Option A, 25 FF. So section would be option A. Next question. How many days notice is the employer supposed to give before closing down an establishment as per section 25 FFA? So the notice period would be of 60 days. That is option B. Next question number 4. If an undertaking is closed down on account of unavoidable circumstances, the compensation is to be paid to the workman under clause B of section 25F shall not exceed his average pay of how many months? 3 months. Option D. Next question. Which section deals with the prohibitions of layoffs? Layoffs are given in section 25M. Its prohibitions are in section 25M. Next question. What is the penalty faced by an employer if he lays off or retrenches an employee without prior permission? The answer would be all of the above. That is option D. He could get imprisonment for up to a month and a fine of up to 1,000 rupees, or he could get imprisonment for up to a month or just fine of up to 1,000 rupees. Next question. Question number 7. The penalty for closing an undertaking without prior notice is how much? What is the penalty for this? Imprisonment for up to 6 months, or fine up to 5,000 rupees, or again both. So the answer would be all of the above. That is option D. Next question. Match the following sections with their penalties. So penalty for committing unfair labor practices, it is provided in section 25U. Second, penalty for other offences, they are provided in section 31. Then penalty for breach of settlement or award is provided in section 29. Penalty for instigation is provided in section 27, and penalty for aiding illegal strikes or lockout is provided in section 28. So the answer would be option A, that is first B, second C, third D, fourth A and fifth E. Next question. State true or false. A proceeding under section 33 and section 33A is pending before a tribunal or national tribunal can be transferred to a labor court. Is it true or not? Yes, it is true. That is option A. Next question. Again, true or false. No employer shall, during the pendency of any such proceeding in respect to an industrial dispute, take any action against any protected workman concerned in such a dispute. Yes, this is true. Again, next question. Which section covers the definition of continuous service? It is provided in section 25B. Section 25, all the clauses of section 25 are very important, so please study them. Next question. How many days of service will be termed as continuous service when working in a mine industry? Answer is option A, 190 days of service. Next question is again true or false. If a workman is laid off for more than 45 days, no compensation shall be payable in respect of any period of the layoff after expiry of 45 days. Is that true? Yes, no payment would be payable. Next. A workman who is employed in an industrial establishment in the place of another workman whose name is borne on the muster rolls of the establishment is known as the badli workman. That is option C. How much compensation does the workman deserve at the time of retrenchment? So the workman deserves pay which is equivalent to 15 days average pay. That is option A. Next question. Which section deals with compensation to workmen in case of transfer of undertakings? This is provided in section 25FF. That is option B. Next question. Retrenchment is defined in which section? This is important. It is defined in section 2. Clause OO. So this would be answer A. Next question, which provision of Industrial Disputes Act 1947 prohibits the alteration of service condition during the pendency of the proceedings? This is provided in section 33, that is option B. Next question number 19. Under section 35, no person refusing to take part or continue to take part in an illegal strike or illegal lockout shall be, part A, be subject to expulsion from any trade or society. Second, to any fine or penalty, or to deprive of any benefit or any right to which he or his representative would otherwise be entitled. Or fourth, be placed under any disability either directly or indirectly, or any disadvantage. So the answer would be all of the above. So the person who is not willing to take part in the strike, he would not be subject to any of the above, all of the above given conditions. Please read this, and this is important. Next question number 20. Unfair trade practices are defined in which schedule of the Industrial Disputes Act 1947? It is provided in the 5th schedule. So answer would be option C. Next question. Special provision as to restarting of undertakings closed down before commencement of the Industrial Disputes Amendment Act of 1976. If the appropriate government is of opinion in respect of an undertaking of an industrial establishment to which Chapter 5 applies, can direct the employer to restart if, again the answer would be all of the above, that such undertaking was closed down otherwise than on account of unavoidable circumstances beyond the control of the employer. Secondly, that there are possibilities of restarting this undertaking. Thirdly, that it is necessary for rehabilitation of the workmen employed in such undertaking before its closure, or for maintenance of supplies and services essential to the life of the community to restart the undertaking, or both. And the restart of the undertaking, what will it do? It will not result in hardship to the employer in relation to the undertaking. So these are all important clauses. This is provided in section 25P. Please read it. The answer would be option E, that is all of the above. Next question. No compensation is required to be given in case of layoffs, retrenchment and closure of any establishment if, option A, employer offers any alternate employment. Okay. Next question. Question number 23. Chapter 5 of the Industrial Disputes Act 1947 is applicable to establishment where in which more than 100 workers are employed on an average per day working basis in the last 12 months. This is very, very important. Please read this. This is a very basic question. Next question. Industrial Disputes Act 1947 provided for the amendment of first schedule in public interest by appropriate government. Then last question. Question number 25. An employer who intends to close down an industrial establishment under Chapter 5 must apply for taking prior permission basically. How many days before? Before 90 days before the intended date of closure. So answer would be option C, 90 days. That's it guys. Thank you for watching. We are done with the labor law important MCQ series. I'll bring up more MCQs later. Thanks for watching. De jure. Stay tuned.